All right, good morning, ladies and gentlemen. Welcome to Senate Judiciary. Ms. Ogden, if you'll call the roll.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Here.
8, and we have a quorum.
All right, we do have a quorum. Ladies and gentlemen, last week we had a bill by Senator Orr that we took some testimony, had a public hearing on. As you may remember, it was a very significant issue to the family that came and spoke, and to other folks around the state, including law enforcement officers, realizing the gravity of that piece of legislation and what it means to the citizens of the state of Alabama. I'm going to ask a couple members to serve on a subcommittee to examine it a little further. Senator Orr, since it's your bill, I'd appreciate you serving on that. Senator Bell, I think you had had some thoughts when we were in committee meeting. I'd ask you to serve on that. If there's any other members that want to serve on that, we can certainly add you. To those in law enforcement or other members who have some concerns or thoughts, who would like to be a part of that process, that further discussion, I'd ask for you to get to with those members that I've called out this morning to talk about that issue, so that we can try to put together a good piece of legislation and see where it goes. Senator Orr.
Thank you, Mr. Chairman. And I just want to thank you for doing this. It's going to take some time, and I appreciate your willingness to engage in this format, because it is a tough issue, and we don't want to do anything that's rash and harms law enforcement, but we certainly need to look at public safety in this context and see if we can make improvements. So thank you for doing this, and look forward to working with the good senator across the way, and we'll see what we can come up with. Probably won't be this session to be able to come back with anything, but I'm certainly committed to the issue, and I know Senator Bell is as well. And if we're back, we'll be back for this committee with a product. So thank you, Mr.
Sounds good.
Chairman,
thank you for your interest. Senator
I'd
Figures.
like to serve.
Senator Figures, you're appointed to serve on that committee, and thank you for your willingness to do that. All right, up first today, Judge Jim Hill, Representative Hill, Chairman Hill is not with us, but we do have two of his bills. Senator Weaver is going to carry the first one. There's a public hearing on, and my intent is not to vote on that today. It's HB 228, and we'll, Senator Weaver, if you'll tell us about Judge Hill's bill, and then we'll start the public hearing.
Thank you, Mr. Chairman. This bill is a revision to ANIA's law, and these changes were a product of a committee of judges and DAs who got together over the summer and over the past year to discuss procedural changes that needed to be made with ANIA's law. And it does a couple of things. It provides that the pretrial detention hearing must be set within 10 days of the defendant's arrest. It provides for continuance of such hearings and requires a record to be made of pretrial detention hearings, and provides for appeals of pretrial detention orders.
Thank you, Senator Weaver. Senator Smitherman.
Thank you. Senator, first something that concerned me when you just said that you said we've had DAs and judges and they made recommendations. We don't have any defense attorneys. Everything ain't slam everybody. It probably would have been wise to have some defense attorneys with that group as well. Just simply because, number one, let me tell you, a problem I see there is that in the preliminary hearing itself, it's a hearing of discovery. That's where the court system is set up to where that's where the defendant is able to address the investigator, the report, and in other words, that's where they get an opportunity to see what's against them, what evidence is there, and then the attorney is able to question the quality of the evidence and the specifics thereof. And these hearings, this is just basically focusing on whether this person ought to get bail, which is nothing wrong with those hearings. That's where it is now. But to eliminate a preliminary hearing because you're having a bail hearing, then, you know, you're telling a defendant that you don't face and deal with what you got to deal with until you get up here at circuit court. You through at district court. Okay. You got a situation where the defendant, they don't go to the grand jury. They can't do it. They don't know. They don't get that information. So now we're talking about on the back end of this, that all of a sudden now this is where this takes place. That's very difficult. And as much as we want to slam people, you know, which some of them probably need to be slammed. Don't get me wrong. But we don't live in a police state. We stay in a democracy. And a democracy is that a person is innocent until proven guilty. And you have the opportunity for a review and to face the person who is accusing you. Here, you're eliminating that aspect of it when you don't have the preliminary hearing. So the only way that something like this can work is that the first of all, you have to have the standards of preliminary hearing. The second thing is that that's not going to be adequate time for the, lack of a better word, the DA or the police to either gather up all this information. Just take this for instance. Here's a city over here in the county who is handling this case. Now, that person is going to be moved to the county. They're in this city. That's because the city officers were the ones who went to address, even though it's a felony. Now, when this person is moved over here, this information is not going to go when they go over here and they put them over in the county in the jail. Because they ain't even had time to get this information together. And I say that because I'm an attorney. And, you know, and just for off the record, I'm still trying to get some information for something that happened 3 months ago. It's out there, and everybody's working to try to, I think, to get it. But in this case, you know, I don't have it if I'm at this hearing, if we treating it like a preliminary hearing. The people I subpoena, the people who's supposed to be there, they're not going to have it. And we're saying this is the shot. But so we're really violating the opportunity for them to be able to confront the person and get whatever it is that they are alleging is what or the basis for why they are there. So I got some problems with that, and I can't let this as myself become law under these circumstances, because it's you know, once we make a law, it's a law. You know, and yes, I realized about the Anaya situation, and I understand what they're saying in there, that was your shot at the preliminary hearing. I've heard some lawyers even say on the other side, not on the defense side, they said, well, you know, that's ain't nothing else gonna come up anyway. This your chance to get it. But no, that's not the case, you know, at all. So I got serious problems with that for that constitutional reasons, you know, and so I won't be able to vote for it because you know, for what I just said. Okay.
Thanks, Senator Smitherman. Let's go ahead and start the public hearing. We have an opponent, Ms. Aaliyah McKee. Ms. McKee. And welcome to Judiciary, Senate Judiciary again. I'm proud Montgomery representative here, and so thank you for being here. And you come to speak in opposition. If you would, just make sure the committee members know your position, and we'll give you 2 minutes or so.
Yes, sir. Thank you. I appreciate the opportunity to be here. I serve as the Chief Public Defender here in Montgomery County, and while we all share the goal of public safety, as I am a resident and I raised my entire family here in Montgomery and I have my entire career, the expansion of the Anaya's Law creates a perfect storm for due process violations. We're proposing a system that would continue to hold citizens longer without evidence, exacerbates a system that's already in crisis, and provides no safety valve for the innocent and those justified in using deadly force in the state of Alabama. What is unprecedented is not only the extension of a 10-day extension without any evidence or proof against a particular individual, but the idea that we could hold someone for up to 21 days for what's alleged to be good cause, which what we see in practice in court is actually if someone's child is sick, if someone's on vacation, these things simply alone can be enough to delay a citizen in this particular state to be detained. In those 10 days, in those 21 days, an individual's without income, they are without being able to be available for their family to support their children that they're responsible for being for, and can have detrimental impacts on not only the lives of them, but the lives of the community in which they are living in. The fundamental requirement of due process is the opportunity to be heard at a meaningful hearing, at a meaningful time, and in a meaningful manner. The United States Supreme Court has found that a prompt hearing is necessary, and that the limitations of any Bail Reform Act or law have to be followed with care and precision. The concern with the current changes and the amendments to this particular bill do not provide some of the fundamental protections that would be necessary in order for this bill to really have the protections that it needs for every particular citizen in this state. Things like the Speedy Trial Act. There's nothing that guards against the length of time that an individual would be held if they're held on no bond, or even a bond that is excessive that they're unable to make under Anaya's law. An individual has no protections if there's no remedy expressly stated within the amendment that if the 10 days is violated, if for some reason the 21 days is violated and a hearing is not heard, there's no remedy for what is stated like currently in Rule 7. That's available to both prosecutors and defense regarding that if an individual is not seen within 72 hours on a non-Anaya's law felony, that they are to be given a bond within the lowest amount of the range set based on what's set by the Alabama Supreme Court. The lack of these protections violates due process and has the real-world impact of not only affecting individuals that I think in our minds that we want to keep off the street, if that is a concern, but it will absolutely capture business owners who defend themselves,
Ms. McKee,
homeowners.
Ms.
Yes.
McKee, thank you for your comments. I do want to ask you a question
Sure.
because from the defense side of the equation, it seems to me that some would call it a delay, but that extension of time period for that hearing, doesn't that also give the defense attorney better time to prepare for that hearing?
There is obviously more time. If there's more time put into that, there is an opportunity to further prepare. But the 3 days that's already permissible and the 5 days under the current rule is more than enough time for defense counsel to not only be appointed, but make contact with the individual who is detained, and also to reach out to their family members. Those point of contacts come from the individual who's detained. They're readily available to counsel at the moment of appointment, and that is sufficient time. I think there are alternatives, though, rather than extending the period to 10 or possibly even 21 days, that if there is a concern by the legislature of counsel's readiness for pretrial detention hearings, amending it where that would allow defense counsel to have the right to possibly waive the hearing at that initial appearance and bring that issue back to the court is what would be more appropriate and more on a case-by-case basis versus it affecting every single individual who's arrested in this state on charges like this. There's also the opportunity still under the current law for non-Anaya's law and Anaya's law felonies that even the prosecutors can file motions to reopen pretrial detention hearings if there's new information, and they always have an opportunity to request a new hearing if significant information has changed that they are become aware of. There are already procedures in place for this to take place, and extending the period of time that someone sits in detention without an opportunity to challenge the evidence. And even if it's not a challenge, to present new evidence that's even helpful to the prosecutors. And in our jurisdiction, what we've seen, some of the evidence that we've presented at these hearings, some of the evidence that we've presented specifically at a preliminary hearing after the fact, is information that's used by prosecutors to present to the grand jury and results in different charges and results in no bills at different times.
Ms. McKee, thank you for your comments. You bring up some good things to think about. Thank you.
Mr. Chairman,
I
I have a bill in another committee that I have to get to, but I wanted to ask a question of the sponsor. Senator Weaver, has something happened since the initial law was passed that the DAs and the judges saw the need to change the bill, that it wasn't working as it was? And I mean, I agree with Senator Smitherman about having everybody from all sides at the table when you change something. But if you could answer that for me.
And so I know there have been some specific instances. I know that Representative Hill had had some discussions related to those things. And I think that Ms. Bates is here and could speak to that if you don't mind.
Sure,
her.
be glad. Ms. Bates, would you mind coming up? And of course, everybody on the committee
Mr.
knows you, but if you could identify
Mr. Chair,
yourself.
if you could tell everybody that that bell they're hearing is the end of their time. I think the young lady before her thought that was somebody's phone just going off.
Fair comment. Ladies and gentlemen, it's only public hearing. Ms. Bates, you know this, being here before, but when you hear the phone or the alarm go off, that's the 2-minute mark. So we'll give you a little bit of latitude, but go ahead,
Thank you.
Ms. Bates.
Good morning, members of the committee. Thank you for your time. Senator Figures, a couple things that came to light since the enactment of the law is that these pretrial detention hearings, also known as the NIAS law, take place within 3 days, right? And then the judges turn around, the judges, the defense attorneys, the district attorneys, then turn around and have a preliminary hearing a few weeks later, and it's basically doing things twice. And it's not judicial economy for all parties involved, quite frankly. And so by extending the time, that gives the defense attorneys, the prosecutors time to get more evidence, more discovery, so that they can better represent the victims and the defense attorneys, their clients, so that they are able to have the hearing one time and not do it twice. Now,
So were defense attorneys included on this new conversation, in this new
no,
conversation?
no, ma'am, they were not. Now, there were many discussions on how it would affect defense attorneys, but they were not in the room during the discussion.
To express for themselves.
Correct, yes, ma'am.
Thank you. Thank you, Mr. Chairman.
Thank you. Senator Bell?
And I guess from a practical standpoint, a lot of times you don't have the information either side within the first couple months. And that's the concern I've got if you do away with the preliminary hearing. We had a bill last session that I think we both spoke about. And if you do away with the preliminary hearing and it's this early, there's times with forensics that you may be 6 months waiting on forensics that totally changes the case. That's my concern on it. I believe in giving the judges all the discretion they need and not have it in 21 days or, give the judges discretion to run their case. The problem is if there's forensics evidence out there and things of that nature, I'm worried about doing this, that it hurts the case. On both sides, it goes both ways. That's my only concern.
Senator Weaver?
Looks like we have a little work to do on this bill. You're not planning to vote?
Not planning on voting today, and we've all the folks that have signed up on the public hearing have been able to speak. So from that standpoint, I'd say we're going to move along. If you've got an interest in this, make sure you try to get in touch with Judge Hill. He's the sponsor of that. Ask the parties to continue to work together to see what resolutions there could be. All right. Next up on the agenda is a bill that we've already passed out of here. The same bill as HB 282. I'm actually going to carry that for Judge Hill. Got a motion for a favorable.
Second.
Second by Senator Smitherman. Ms. Ogden, if you any further discussion, Ms. Ogden, if you'll call the long roll for me.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Aye. All right. Bill is given a favorable report. Next up, SB 273, Senator Orr.
Thank you, Mr. Chairman. Members, I'm going to send around a letter. There's been no public hearing on this bill, but I've sent around a letter. I've got people that are interested in this bill. It's a simple bill. When I got into it, the offense of stalking, the problem becomes when in serial offenses that law enforcement or prosecutors are held with only a misdemeanor, and we've got a situation where multiple people from a class back, I think, middle school, now they're all adults in their 30s, and they've got somebody from their middle school class that is stalking all the 6 or 7 members of this class, and they're kind of scattered around the state. You got one lawyer in Birmingham, you got a dentist, I think, in Madison County, you got an insurance guy in Decatur, you got somebody in Lawrence County. and there's a couple others just scattered around from this school class of 15, 20 years ago. And an individual is making threats and things like that, but the law doesn't have the teeth for repeat violations, and that's the reason for the bill to escalate it to hopefully stop this. But the threats, with small children and things like that, there's a real concern, and the prosecutors just kind of shrug and say, well, we can't do anything else unless they come to your face and really go beat you up kind of thing. And that's, that's kind of the dilemma we're in. And so that's the reason I bring the bill and would like to move favorable, Mr. Chairman.
You got a motion for favorable. Senator Smitherman, did you have a?
I got a question,
Sure, go right ahead.
but he got his motion. You probably
You-
second from somebody.
I'll second. You go right
And I
ahead.
think Senator Figurs had her hand up a little bit before I did.
Thank you, Senator Smith. Mr. Chairman,
Go right ahead.
I just wanted to say I am a victim of a stalker, and I had actually, after my experience, because this person, I don't know how long he had been following me or whatever. I think it had been well over a decade or so, but he showed up at my door one morning, and we later found out he had a gun in a holster, and then he came back to my house the next day, and that's when he was arrested because something's wrong. But I didn't answer the door that morning, thank God. But we couldn't do any more than the judge couldn't do any more than he did because of the law.
Yeah.
So I appreciate you bring this. I've also had a stalker on social media, which that's why I don't do social media at all. But I appreciate you bringing
Thank you.
this bill.
They're really good people, but
Yeah,
the law just won't give them the teeth that it needs, and this
That's
person
right.
just
and that's what I
and they're real
experienced in his
threats, like
trial.
yeah, I'm
Well, yeah,
gonna kill
I mean,
you
you
and
don't know.
take your wife.
And why is it you have to wait until something happens before?
Mhm.
So thank you.
Thank you, Senator Figurs. I'll allow, if you want to, I'll allow you that to be a second to his motion then. Senator Smitherman.
The question I have, first of all, I'm gonna vote for the bill, and I agree with it, everything that I've heard. Let me say that. But the question, though, and I want to sponsor. These are lawyers, so that's easy to tell
I'm
him.
not a criminal
I tell-
lawyer.
Yeah, no, you ain't got to be a criminal lawyer. Not you a lawyer. You
got
learn
that
it.
over there.
You learn it. Learn it. Look, what is the definition of a person stalking? Now, and let me tell you why I asked that. It's because I know one judge ordered you not to have any contact or do anything like that or whatever like that. That's clear. But if I'm trying to use the right words to say that prior to a judge's order, what then constitutes? And you said, what do you mean? What constitutes? Alabama Auburn playing basketball game in Tuscaloosa. That person go to the game. The person the stalking go to the game. They in the arena. They are not ain't nobody following them or doing anything. They just in the arena, no court order, anything. Then at that point, because they are in this arena, that constitutes that means that they're stalking. I ain't talking about somebody following somebody around and like you saying or whatnot. But does that mean that they're not barred from any public event or anything? So then all of a sudden somebody says, I saw him over there and go get the police, whatever. Then does that constitute then that they fall under this, that because they're at this ball game, they're finna get a felony? Can you tell me what that is?
Good question. So right now, for a misdemeanor stalking, it's intentionally, repeatedly follows and harasses and causing material harm to the mental or emotional health. So they got to make contact with you. They don't just, they're over there in the seats and the bleachers and you're over here and they're just at the same place. They've got to cause mental harm, emotional to your mental or emotional health, and or a reasonable fear that you may have. And it wouldn't be reasonable if you got 5,000 people sitting there and they're over there and you're over here.
Okay.
That wouldn't be a stalking, for my interpretation of the misdemeanor.
I'm just, when a person is subject to that, Of course, you know, I like a better word, they scared. They're supposed to be scared because you got somebody doing that. So it's just fact that they just done
They
freaked
got
out
to take some
and said,
overt
I
steps.
see him, you know, this is the person and this is this, and then they just in there
No, they got to take overt action
toward that person.
towards you. Yeah.
And then
Then you're triggering.
that's
stalking.
good enough. Okay, thank you.
Yes, sir. Senator Coleman Madison.
Thank you, Mr. Chair. I'd just like to follow up on Senator Smitherman's question. I don't see a definition of stalking here. I just looked it up, but I don't think they're going to go by definitions. Webster, maybe, in the court case. I just wanted to know what is the definition as it's not defined in the bill.
Well, let me say, can I
Maybe
let me
somewhere
answer
in the
that?
code.
So, whether or not it's even further defined in the code, but exactly what Senator Orr said, if somebody with improper purpose intentionally and repeatedly follows, harasses, telephones, initiates communications verbally, electronically, or otherwise with another individual or any member of that individual immediate family member, I'll skip through here because it does have some extra language in there, with the intent to cause mental harm to the mental or emotional health of the other person. That is already law, and we're not changing that. It is just simply changing what a conviction, a second or subsequent conviction, the punishment would be. So we're not changing the underlying offense and what the proof is that would have to be. We're just changing the potential
So
punishment.
is this
there.
the reference to section 13A-6-90?
Yes.
Okay.
Yes, that is correct. Okay, got a first and a second. Any other discussion on the bill? Hearing none. Any opposition using previous roll? Hearing none. Bill's given favorable report. Thank you, Senator Orr.
Thank you, Mr. Chairman.
Next up, we've got HB 7, and Senator Woods, you were here, I believe it was last week, may have been the week before, and we talked about this. At that point, and I'll let you address this. We actually, I believe, adopted an amendment, and I think your request for this committee is going to be, and I will certainly initiate that, is that that committee amendment that we'd adopted, that you want to rescind that. And so I'll let you explain the bill again, what we did on the amendment, why you believe it should be rescinded, and I understand there is in your package there should be a sub. So.
Yes,
Senator
sir.
Woods.
Thank you, Mr. Chairman and members of the committee. I appreciate the opportunity to present HB 7 again to you this week. The amendment last week that was added on is dealing with students with disabilities. We're trying to make it clearer that they had some opportunities for hearings and such, in addition to what is listed in this bill. We have better language in an amendment that hopefully will be offered in just a moment, and I can clarify and expand on that, but would ask we remove that so we can have a better definition added with a new amendment.
Right. I'm going to make a motion that we rescind the amendment that we'd put on there at the last hearing. It's a second by Senator Bell. Any further discussion on that motion? Hearing none. Any opposition using previous roll? Hearing none. That amendment that we'd previously added is now tabled.
Thank you.
Removed.
I just want to say I appreciate the dialogue we had last week. I think it was very helpful and constructive to this bill, and that those conversations continued over the weekend. Spoke with a lot of the education community and with student advocates, and I believe that we will have an amendment, hopefully, that will address concerns from last week's discussion and make this bill better.
Members, any discussion or any motions?
Mr. Chairman,
Senator Smitherman.
you ready for me? I have an amendment that you pass that to him. And if the desk will read it so everyone would know what it would say.
All right, members, do y'all have a copy? Do they have a copy of that?
Do they have a copy?
I emailed a copy out.
Okay.
Okay, it should be in your package then. Let's make sure that that's,
And while you're looking for that, Mr. Chairman.
yes, sir, go right ahead.
Okay, thank you. Just to give a little background to the members, the terrorist bill that he is working from and building on to do what he's doing. I always do it pre and post. Thank you all for supporting me because I actually passed the bill. And in part because of the threats at that time to the Jewish synagogues and whatnot. And that's part of my Senate District 18, that's in Senate District 18. Then you all were nice enough to support me with the due process with the young people in education. So what this amendment does, it takes into account the students who are disabled, and primarily that's what we sat down and had to look at, because as I give this analysis, you know, a lot of people don't understand ADHD, opposition defiance. They look at it as a child being a certain way, and these kids have medical problems. They take medicine and whatnot, and so to be able to trying to put them in a category with kids who you look at their actions or their reactions, and then look at it as being a conscious defiance of what they're supposed to be doing and not doing, and yet it's not the case because they have some mental illness problems. And so what this does is put a division of how they address through due process and how they address and what is brought in to consider how that has to be addressed with them. We have federal laws, the 504, you know, and then we have, I can't remember, but there's another federal law in there we already under. And so what this does is codifies those rights and due processes that already exist from the federal level. So when you make that attempt to address this under the disabled students, then you go through that litany of steps that are already there to make that determination.
Senator Smithman, I know you've always been an advocate for children, and especially those who have some needs other than other children do. So I appreciate that.
Thank
you. The amendment that you've offered is in your package. You got a favorable motion for favorable by Senator Smitherman on the amendment, second by Senator Bell. Any further discussion on the amendment? Any opposition using previous roll on that? Hearing none, the amendment's adopted. Back on the bill as amended. Motion
I second it.
favorable by Bell and second by Senator Smitherman on that. Any further discussion on the bill as amended? Hearing none, bill's given a favorable report. Thank you, Senator Woods.
Thank you so much to the committee. I appreciate you.
Mr. Chairman, can I make
Yes,
just
sir.
a quick comment?
Go right ahead.
I want to thank Senator Woods. I mean, I done been here a while. I ain't seen nobody as thorough and work any harder to touch everybody in the Senate to try to work through whatever it is. That's what it's all about. I mean, I'm serious. He needs these flowers. It's why he's living. That's what it's all about. Being able to work with everyone to figure out how you do what you're trying to do and don't lose the value of what he's trying to do, but at the same time address, once again, as I always said, the wings on the airplane.
I think he's touched both wings and everything in between. On
He
that.
has. And all who agree, let's say amen.
Amen.
Amen. Thank you
All right,
both.
thank you, Senator Woods. All right, next up is a bill that I have. It's SB 296. Members, there's a substitute in your package. Yesterday I had some conversations with some folks that had some concerns about it. So we are not going to vote on it, and I want to limit conversation really briefly or have Mr. Bob Maddox. Bob, would you mind coming up and just addressing what the intent of the bill is, why CASA representatives are important across the state, and their advocacy. That's it, for children. And then, members, if we could, because we're not going to take a vote, we're going to carry it over. We won't necessarily entertain any questions on it today. Mr. Maddox.
Good morning, Mr. Chairman, members of the committee. I'm Bob Maddox, State Program Manager with Alabama CASA Network Incorporated. CASA stands for Court Appointed Special Advocate. Alabama CASA Network Incorporated was actually incorporated in 1997, almost 30 years ago. And really, we have 16 programs around the state of Alabama who are independent nonprofit entities or part of umbrella nonprofit entities who actually recruit, screen, and train citizen volunteers who are unpaid in juvenile courts in dependency and termination of parental rights cases. The purpose of this bill is basically to clarify the authority of the juvenile courts and establish a statutory framework for volunteer advocacy and dependency in TPR cases. Currently, there is a statute that authorizes juvenile courts to appoint these volunteers. It's in 12-15-304D as in dog. It does not reference CASA or CAJA in it. CAJA stands for Court Appointed Juvenile Advocates. There are 2 counties in the state of Alabama who use CAJA volunteers, Marshall and Madison. They had to use that name from my understanding because there were already CASA entities in those counties. So they formed the name CAJA. But anyway, we are not really changing current law. We're just expanding on the juvenile court's authority. We're not changing juvenile court's discretion or limiting their discretion in appointing these volunteers. We are not changing the current confidentiality statutes in juvenile courts, both as well as in federal law. It basically establishes the statutory framework that's really been in existence. This program's been in existence for over 40 years. I believe, according to our historical documents, Jefferson County was the first CASA program in 1985. So this program has worked in about 24 counties in the state over these 40 years. Also, Alabama is currently the only state in the United States of America that does not have a law specifically authorizing CASA CAJA advocacy. While Alabama does have the little provision in the Alabama Juvenile Justice Act authorizing the appointment of volunteers in general, there is no specific reference to CASA and CAJA. So this is another purpose of this bill, is to try to get that codified, to codify our entity, the state entity that supports and trains the local programs, and also codify the local programs, make them be a member of the Alabama CASA Network Incorporated. So basically, we're moving forward with the program. We currently have the authority. There are also 2 court rules, Rule 42 Rules of Judicial Administration and Rule 6 Alabama Rules of Juvenile Procedures that authorize juvenile courts to appoint volunteers. So there is current authority. We just want to establish a statutory framework for consistency, clarity, and accountability.
Thank you,
That's
Mr.
basically it in a nutshell.
Thank you, Mr. Mayor. Will you just, for the committee, let them know your past history of service to the state of Alabama and how that works?
Yes, sir. Thank you. I did serve in the legal division of the Administrative Office of Courts for almost 35 years, retired on November 1st, 2024, and have been in this position a little over 15 months. So I'm here representing Alabama CASA, not the Administrative Office of Courts, obviously. So wanted to make that point clear.
Thank you for your advocacy for the children around the state and for your service to the state of Alabama. Senator Coleman Madison, then we're going to move along.
Yes, sir. I don't want to prolong the agenda here. You say you're going to not vote on it today?
No, we're not. There's some tweaks that we're looking at potentially making, so you'll probably see it next week.
Okay.
That's correct.
Thanks a great deal. I was just wondering why we're holding up.
Yeah. Thank you. Thank you, Mr. Maddox, for being here. Members, I'd ask you to continue to consider that, and
appreciate it.
Thank you for being here, and we'll probably see that next week. All right, SB 199, Senator Kelly. And before we get started, there was a public hearing that was called, and we had a sign-up sheet. Is there anybody here to speak in opposition of SB 199? Okay, well, we've met the requirements, my internal requirements at least, of calling a public hearing and seeing that nobody is here. Senator Kelly, tell us about the bill, and then we'll entertain motions to move the bill forward today.
Thank you, Mr. Chairman, and I appreciate the endorsement by nobody speaking against the bill in the audience today, considering how distinguished this audience is tonight. I would like to acknowledge Representative Butler's work on this bill. He's put a great bill, did a time into it, and so we appreciate your efforts. This bill allows parole and probation officers to restrict adult sex offenders convicted of child-related offenses from using post office boxes, electronic media, and authorizes the boards of pardons and paroles to require sex offender specified treatment and periodic polygraphs. Now, the violations of these would be a Class C felony, and it authorized the pardons and paroles to adopt rules related to this. Now, the only adult sex offenders convicted of child-related sex offenses are affected, and it does not apply to any low-risk offenders or non-child-related offenses. It does not change the registration requirements. Offenders are increasingly using anonymous digital tools, and current law does not give officers clear authority to restrict that internet access. And what's happening is they're grooming the children. And so what this is an attempt to restrict that grooming of children.
Thank you, Senator Kelly. If I remember correctly, this bill or a version of this pretty close to this passed out of committee.
House version that's passed, yes, sir.
Okay. Senator Smitherman.
Are these, on our sheet, and I probably need to just go to whatever attorney and clerk and you, is that, are these elements what's a significant section analysis? What's the new aspect that we are doing with this law? Is all of this new?
All of this is new.
Everything that's on down here?
The initial
Everything new right here?
The initial aspects are all new.
Okay, all right, and what are the elements for the parole officer to make that determination that this is happening and they need to do that? I mean, it's got to be something. They're doing this happened, and this happened. So as a result of that, the elements are there, and then the parole officer can, whatever it is that this bill allow them to do it. I don't see elements in here. It's just saying that if they say that if they say they doing it, then they, if the officer say, okay, you doing that, then it kind of sets the officer to be the judge, the jury, and everything, and they ain't qualified to be no judge. They're not qualified.
Well, it does give them the authority to set up the rules and restrictions to it. I'll be glad to have some further dialogue with you to if you've got some concerns, thinks there needs to be some tightening up there, I'd be glad to work with you on that.
Yeah, on the elements for them.
Yes, sir.
I like what you got down here when you said that about the courts.
Yes,
coming in and making and setting what it is that they're supposed to do. That's not what I'm saying, but I'm dealing with the front end of it.
I understand what
before we get to where the court said it.
Yes,
said what it is. We're allowing this parole officer to sit in their own mind. What should or shouldn't be. So
yes, sir.
If we can get together on just whatever it is that exists. Just whatever standards that you see that needs to be exist, they just put some standards there.
Sure.
Okay.
I'll be glad to work with you on that.
Okay, thank you.
Thanks, Senator Smitherman, Senator Kelly. Any other discussion on the bill? Senator Coleman Madison with a question.
Thank you, sir. Senator Kelly, can you explain and give me an example where you mentioned that the bill authorizes the Pardons and Parole officer of an adult offender who is convicted of sex offense involving a child to restrict the sex offender from using a post office box or processing any electronic media, including but not limited to a computer, tablet, gaming system, or phone that allows access to the internet. Give me an example of a person who has a job that uses a computer and has to access the internet. It doesn't, I don't see a distinction in here in the bill that it references specifically trying to communicate or with a child or whatever.
Mm-hmm. So,
help me understand.
Well, and you're absolutely right as far as it relates to a job. If they use the internet with their job, that could be the problem. What they're doing is they're going on putting false names, registering for accounts, even post office box, and using anonymous names, and basically coming back on the internet and grooming these children to be victims again.
Do you think it needs to have some specificity in here where you said using other names, anonymous names or what
Yes,
have
ma'am.
you, to be specific? Because if a person is working, maybe this person, okay, I've been convicted, I'm a sex offender, I've got a record. but I've got a job now. I'm trying to get myself straightened out. And part of my job is using a computer. I have to go on the internet.
Yes, ma'am.
So how does this mesh? I'm just trying to make it work. I think you got a good bill. It's just that little issue there, to me, that person has that record. They don't have a choice. I can't work. I'm convicted. So what can I do?
Well, I would also submit there are a lot of jobs, of course, that don't require access to the internet. I would think that there would be some avenues that an employer could do, because most employers are going to know whether there are sex offenders working for them or not, that there may be some filters put on there at work. I'd be interested in going further with you on that. I understand what you're saying. I also know we've had some issues in the past in prisons, even in the prisons with the securities and things like that, that there's been some abuses in this area as well. I'd be glad to entertain what thoughts you have and work with you on that.
I'm aware of that, but I'm a little uncomfortable. I see what he's trying to do, but I wish that there was something, and I'm not an attorney, that we could put in here. Of course, if a person is using an anonymous name and he's found out to be doing that, but I do not want to limit a person who has gotten out, served their time, and trying to get their lives straight. This person may be a computer specialist. That's what they do.
I don't want to interfere with anyone's ability to earn a living after they serve their time.
Let's do this. Representative Butler's back there, and he's got his hands up. But here would be my request to the committee. Senator, if you want to try to move this bill along, if the committee's fine with that, you've given an indication. First of all, I think some valid points and questions and considerations. And just with the understanding that you will try to work through those issues before, if this committee gives it a favorable report, before it ever sees the floor. And Representative Butler, did you want to address really quick?
If I could add a component to the bill, and keep in mind, this is not a shall, this is a may, and it allows that discretion to the pardons, parole, and the judge. But one of the components is sex offender treatment and polygraph. And this bill is catching fire across the nation, and the states that have adopted it have seen recidivism drop tremendously. So that's what I was wanting to give to you. They will be able to do that, and it's not automatic to do anything, but the treatment and the polygraph is the huge component to it. So yes, you're going to let them have the computer and the job and all that stuff, but you're going to the judge may possibly subject him to polygraph, and he knows that's over his shoulder. So that's what that's all I wanted to add was that component to the bill.
I think you've explained and answered my question. The point is that the person is not denied the ability to work and earn a living.
No, not at all.
But the polygraph is held over your head. You know that you're going to be tested.
Exactly.
And this will indicate whether you are using this for other reasons. I think that answered my question. Thank you.
Thank you, Senator Smitherman.
And but if take the bill the way it exists now, prior to you all changing. I want to say that because the way it's being presented now, all we're trying to do is the polygraph and do that. But in reality, it's about 5 sections. And polygraph and that is just in one. And we got 4 other things that we are changing, like what we are talking about now. If we were just talking about polygraph and what you said, I'll be saying next after that. Because I understand where you're trying to come from on that, and I'm okay with that. They need to be on check. That's what that means. But to deny up front, well, somebody, you know what I mean? If you know what I'm getting at now, what she's talking about.
And it is a may, not shall, but it does add that component for the supervision, knowing that possibly they're going to be subjected to the polygraph. But because this doesn't mean they're automatically going to be denied the video games, because, a lot of people play video games and they have conversations the whole time, and you never realize this is some creep that's messing with a child. And the P.O. box adds that anonymity, so that's just adds another tool to the toolbox. Doesn't mean that they will actually employ any of these tools.
Yeah, but we are letting, and I'm gonna be too much. We are letting someone, and I'm not, they're honorable people, just honorable profession, but they ain't lawyers and they ain't no judge. And we letting somebody who's a parole officer have that discretion on May See what I'm getting at? They're not, you know, we're dropping them, we're giving them all kind of authority there, and they really are not, they didn't go to school for that. You know, that ain't what they teach in a degree there about looking at the different areas of law, like in law school or like as a judge, you know. So that's what the problem is. It's not what you're trying to get done. I think everybody at the table, you know, against sex offenders and especially with children and stuff like that. You know, I mean, I think the senator sitting right there, she'll tell you, I voted for her bill, okay, dealing with that. So I just want you to understand that, no, that's not it. But to leave somebody out there who, lack of a better word, is a layperson in relationship to a judge or a lawyer to make a decision that needs to be made at that level, I think that's where the concern comes in, and the automatic denials just because of your opportunity to do those things. You know, that's where the problem exists.
Senator Smithman, good
Smithman,
points.
I recommit my word to you that I'll work with you on that.
All right. Thank you for that commitment. Valid points and considerations that have been brought up in committee today. Members, I'll entertain a motion to move the bill ahead with the understanding that he'll continue to work. Senator Orr has that motion, second by Senator Gavan.
Abstain and hold it because I see something else is in the first section on this analysis. I would like to work with you on it.
Absolutely.
All right. Any other than Senator Coleman Madison that wants to abstain on this vote? Any opposition using previous rule? Hearing none, Bill's given a favorable report. Thank you.
Was I on the last roll? Since I'm not sure if I was on the last roll or not. Okay, thank you. I wouldn't say that very loudly.
All right.
All right. Thank you, Mr. Chair.
Thank you, sir. SB 47, Senator Coleman asked me to handle this. She had some things that came up this morning. This is a bill that we've seen, this committee's seen before. Essentially, and if you turn to page 4 of the bill, the heart of it is that if a child support order is entered within the first year of birth of a child, the order may be retroactive to 9 months prior to the birth of a child, and that nothing in this section is to be construed as authorizing child support if a child is unborn. Got a motion for favorable by Senator Bell, second by Senator Smitherman and Senator Orr. We'll put a couple of seconds on there. Any further discussion on the bill?
Yeah, I do.
Senator Figure?
Mr. Chairman. Yeah, what if the young lady doesn't tell the father of that she's even pregnant, or what if she doesn't know who the father is? What happens then?
There has to be an order of child support issued within a year after the birth.
Okay, so the paternity and all will be proven.
That's right.
Thank you.
Through a court order establishing that paternity and child support.
Okay, thank you.
You're welcome. Yeah. Any other discussion? Having a first and a second, any opposition using previous rule? Hearing none, that bill is given a favorable report. Senator Coleman Madison, can we jump real quick? I've got. Let's see, Representative Butler.
Mr. Chairman.
Sure.
I'm gonna have to leave. I've got to be in the positive bill that I have on there in 5 minutes. So, would you, if unless I need to do it by Zoom, if you would.
You mean to vote for you like Senator Orr was going to vote?
Yeah, I think on our last bill we got 204 in here. So if I can be as a yes on that, I would appreciate it.
Understand.
SB 204.
All right,
HB. I said last SB 204.
HB 80, Representative Butler. I'll note that for time of brevity, I think this bill got overwhelming support in the House. Doesn't mean we're going to do that up here, but if you can really quickly tell us about your
real quickly tell you how it came about. In Etowah County, the gentleman that is with the sheriff's department that handles the evictions called me one day and said, "Mac, what is the law with evictions?" And I told him what I thought it was, that he shows up, keeps the peace while the landlord sets out the property at the curb and they dispose of it and they all lived happily ever after. But he said, "Well, I can't find that law." I reached out to Othney. Othny said there is no law. There is only an administrative rule that deals with foreclosures, which takes the precedence that says the sheriff's department shall go out, inventory the house, load the properties up, and store the properties. Of course, that's not going to happen. All this bill does is puts into law the process. Right now, there's no notification for the tenant. It requires that, and it just lays out the procedure of what we've been doing now, that the law enforcement shows up, keeps the peace, the landlord's responsible for setting the property at the curb, and nobody is liable if somebody says, my grandmother's necklace is missing, it's $10,000. But it just literally lays it out. We had no opposition in the House.
Senator Smithman.
Would you say that again?
Yes, sir. Currently, there is no law setting out the protocol for evictions. Othny sent me the whole process. It goes to administrative rule. He said if somebody went to court, and which says the sheriff's office shall go out, inventory the house, load the property, and store it indefinitely. Of course, that's never happened. So this puts into law. There's no notification requirement now for the tenant. This goes through step by step to notify the tenant what is about to happen once a writ of possession has been handed to the landlord. The sheriff's office comes out, or your constable, or whoever in your county keeps the peace, while the landlord that owns the property sets the contents at the curb or wherever he is directed. In Gadsden, we set the property at the curb. And then after a day, the city of Gadsden requires you to get a dumpster and put it in there to haul it off. But,
Mr. Chairman.
Yes, sir.
But suppose that it's a house that is not a landlord. It just, I don't want to say this, use you as an example, so I'm going to say a person.
Well, this is an unlawful detainer we're talking about dealing with.
Mm-hmm. But listen at this one. You got a divorce. You got man and woman, divorce. Okay. Now, you got the house given to the woman. The man won't leave. See my scenario now? There's no landlord whatsoever. Now, go through what you just said. The landlord do. Now, no, but that, I'm saying that I know of a case right now that's existing right now. As we sit here like this, what I'm telling you. So who then steps in under this scenario and do what you just said?
This is only where a landlord has gone to court and got a writ of possession. He's gone through the process. They've exhausted the appeals. He has been given a writ.
That.
So the landlord...
I'm not trying to cut you off. I got to go to another committee. That's why you see me doing that. I want you to know that. I understand that. But I'm saying in this particular situation, you see what I'm
if someone had not paid the rent and it's my house, the court's going to give me a writ of possession.
A divorce.
Well, we're not dealing with that. This is
but it's the same. It is the
writ of possession.
No. I want to find out what happens under this, because that is the case. You have two people divorced. Other person say, I ain't leaving. Okay. Then, but the orders give this person the property. So it's theirs now, the wife. They got to go through the same process to evict them out of there. The same eviction process.
Well, I would agree with that.
Okay, now stop there.
Whoever gets the writ of possession.
Yeah, okay.
Controls it.
Right. So what I'm saying is that who sets the stuff out? Who's going to be the person that's going to do this? Because it's not a landlord. You just said the landlord under the protection of the police.
Whoever has the writ of possession is going to be in charge of that.
Senator Gavan, he calls himself a dirt lawyer, so I guess he knows.
Well, I quit doing all this stuff years ago, because every time y'all change the daggum law, I quit doing it because I'm not going to bother to learn. But now that I'm helping change it, I try to go along with the flow a little bit more. But my understanding is, I'm not 100% sure on this, but I think the difference is in the scenario where Representative Butler's talking about, there has to be a residential lease to trigger that. Otherwise, we're getting into situations like an ejectment, or that would be dealt with in circuit court, but not summary disposition like there is in district court. With residential leases.
Senator Bell?
I think this is different than a divorce, looking at the eviction law and the way, and I was going to say exactly what Sam said.
Okay.
All right, thank y'all.
You got a motion for favor by Senator Orr.
I second.
Second by Senator Coleman Madison. Any opposition using previous role? Senator Coleman Madison, would you like to be added back as a yes on that? Any opposition to using previous rule with Senator Coleman Madison's addition? Hearing none, bill's given favorable report.
Thank you.
Thank you. Members, we are really up against a time crunch here. We've got several bills left. Senator Coleman Madison, SB 204, there is a substitute. Members, have y'all had an opportunity to look through that substitute? Senator Coleman Madison has spent the past week or so, I think, trying to talk to some folks. Did you want to go forward with it today, or just let members look at the substitute, given the delay of time?
We can let members look at it. I do want you to look at we've incorporated all the changes that I've gotten. We did work with the Association of County Commissioners on this. They're represented. We sat down with it. So those changes, we wanted to make sure. But let me just say what the bill does. And Senator Gavan had issues about redemption, pages 13 through 16 kind of answers that. But this would authorize, and this is the state land bank, authorize multi-jurisdictional land banks through intergovernmental agreements. It allows the land banks to acquire delinquent properties that are tax lien, which is right now they are not allowed to do that. It shortens the redemption period of time for these houses that's been there or land that's been there in the state tax rolls, been there maybe 15, 20 years. Got a lot of liens. Municipal and county governments have maybe cleared off something, torn down a house. Over the years, several attempts have been sent out and no notices, but they still have a period of a year when it goes through that process, because it talked about the due process that they have to notify any heirs or what have you. Senator Gavan had a concern. He mentioned about guardian ad litem, which is something I'm not familiar with. You deal with that process, so you might want to bring something to clarify that. But it does exempt land banks properties from taxes for a period of time so that they can put that money back to be used for redevelopment. It allows the governor to create a land bank if she chooses. We've had a lot of areas throughout the state where disasters have happened, and you've got a lot of that vacant land. So if they want to come together, and this is across counties where you have these large swatches of land, and maybe you want somebody to come in with housing, community development, economic development, but the issue is trying to get the title and working with all those different fractions. And so the governor would be able to do that. Again, all of this is permissive. And again, it enables the land banks to acquire tax liens at auctions, which, as I said, they're not able to do that. So please take time to go through this. This has been a work in progress. It is not perfect, but we're looking at providing another tool in the toolbox for local and county governments to work together to put properties back on the tax roll. Remember, if it's not on the tax roll, state and local governments and schools are not getting any money, which is the source of it. So if you have questions about it, if you have amendments or what have you, I'd appreciate it. So we can carry it over to give everybody an opportunity, because it is a long bill.
Thank you, Senator Coleman Madison. I know it's been extremely important to you, and appreciate your diligence in trying to work with others. Members, we are really out of time. We've got two more bills left, and we're going to do our best. I am not going to rush either one of these bills past, and so to the extent that there's any broad discussion on them, we may wind up carrying them over. But Representative Pettis,
Have we not already done the Senate version of HB 11? I may be wrong.
no, we have
Okay,
not.
never mind. Okay.
Representative Pettis, you came to us last year with this bill. I believe, if I'm correct, that we amended it. That amendment that this committee put on there is incorporated into
Yes.
this bill this year.
It's identical to what come out of this committee last year.
Yeah.
It was
No changes.
All right. Representative Pettis, just 30-second discussion, or tell us what your bill does, including the changes that we made from last year, and we'll see if there's any discussion. We'll go from there.
Okay, what this bill does, it denies youthful offender status for anyone who's charged with capital murder or murder, intentional murder, which is A1. It just denies their part of getting youthful offender.
And if I remember correctly, members, you'll see an individual who is still eligible for that youthful offender application if that charge of capital murder or murder pursuant to 13A62A1 is reduced to a later charge, which I think is important.
Yes.
Because just because you're charged with something doesn't mean that that's ultimately what you're either going to plead guilty to or found guilty of. And so I think
That's
that
correct.
ability for someone to still get youthful offender under that scenario is important. Senator Smitherman.
Thank you, Mr. Chairman. I'm gonna just give a brief comment. I'm gonna run out of here to get to where I said I was going. But I have serious problems with this bill, not with dealing with this issue and whatnot. And my serious problems is simply this, is that we're saying on the very front end, once they are charged, then that denies them. And that decision, then we're taking it strictly out of the judge's hand and giving it to the DA, whether they want to charge or not. And when they charge, that's it. Now, I realize that, what's going on now is that they charge up and then they go through trying to get evidence. And then, of course, at that point, it has an opportunity to be charged down. Okay. But they're denying this opportunity here to get you at YO. Right now, it still rests with the judge. Okay. I really just stay where we are, with that, because I don't want that decision to be there versus in the courts. And you say, well, what are you talking about? And I know regular basis, nothing like that, but you got situations. I just give you a clear example. You got situations, and I haven't seen this happen by no murder, but you got a situation where you got kids, at basketball practice. They got folks there or at the game. They got folks there that they catching a ride home. Them people go by and do some crazy stuff. That person don't even get out the car. They don't even have knowledge of it. Now, because the crazy person went out there and shot somebody or whatever like that, they finna get charged with capital murder, and because it's called constructive. You lawyers know what I'm talking about. Just because they there in the car. And then of course, if you have a situation for the judge can decipher at that point whether this person was a culprit to it or whether they didn't, and then whatever punishment or whatever will be accorded. Under this law, if you in that car and one person did that, then DA can say, we're going to charge all of them with capital murder. Period. No other elements. It gives them that. And no, I can't go along with that. We wiping out young folks left and right who ain't even doing that. And yes, and I'm going to say this and walk out the door. Y'all know I'm forgetting people who do that. The Glocksmith bill, what we passed, okay? So I have to sell that folk. I don't want folks get confused that I'm not right on course with that. But to leave that, to do that to young people, all of them charged with capital murder, and the only person going to have discretion to do that, to drop, not be considered just one time, and that's whether the DA want to consider it or not, versus the courts, I can't support that. I'm seriously against that.
Understand.
So if we vote, just like I said about hers, I would request to be voted no.
Senator Coleman Madison, would the members understand that we're 10 minutes past time at this point? We're now with Senator Smitherman leaving. We will have lost a quorum from that. I understand you've got ed policy and we've got, right. Senator Coleman Madison, you want to make a comment on it, and then based on the fact that we have lost a quorum, we'll continue the discussion possibly next week.
Well, I appreciate the opportunity to take time to really fully vet these, because this is a teachable moment, because we have a number of young people that are here, and of course they are listening. This is another homework assignment for the folks that's in the Senate pages. This is HB 11. Please take time to read it. There will be a test on this when I see you guys again. This is really important because we're talking about age 16. And I can relate to what Senator Smitherman spoke about simply because I'm well aware of a case in my community where you had a group of young men that was in a car, and then they picked up someone else, got involved with a drug deal involving a pistol. One had a gun. Nobody knew anything about it. They got into a shootout because drug deal went bad. Everybody was in the car. But everybody is in Tuscaloosa jail right now on capital murder. Somebody shot, bottom line, somebody got killed. But they are all in jail right now. I see what Senator Smitherman is talking about as far as who makes a decision, how do they peel back the layers and find out what happened. without grouping everybody and painting everybody with a broad brush and saying, you're all guilty.
Senator, thank you, Senator Coleman Madison, Senator Goodman.
So, as I've said many times, it's in my field, but it sounds like maybe there's an opportunity to basically, I think if we could carve this out to where it's just the person who pulls the trigger and everybody else, because I get, you're along for the ride and somebody does something ridiculous. Doesn't mean that you're just sitting there or, should be guilty for that. So, maybe a little carve out on that, because I think what you're trying to get after anyway is the trigger person.
Well, that's in the way it's explained to me usually, and I've got the DA Association here, but I know we're short of time. Normally what they do when they figure out who the shooter is, they drop the charges, lower the charges on the other ones. So this would kick in where the amendment we had on it, they would be eligible for YO, because that's what the main goal is, to get to shooter. And I know the DA said there's a case here in Montgomery that was tried before, and the other one testified against the shooter, but their charges was lowered, so they would be eligible even under this bill for YO because their charges was lowered. And the one who actually did the shooting was not lowered.
Senator Bell?
And that's what I noticed on line 56, 57 through there. That's what makes that change, where if the charges are reduced or charges are changed, then they're eligible for YO at that point.
And I appreciate Representative Pettis working with us on that portion of the bill last year, incorporating that into the newly filed bill this year. All right. With that being said, Representative Faulkner, I think, was here too. He may. Okay. Well, that bill, then we will continue to get you to work on that. Representative Faulkner, sorry that you were here and we did not get to you. Meeting is adjourned.
Thank you.
Does the